Good afternoon, everyone. And we are now starting wave 2 of our only one theme talk series around innovation management. Very happy to go ahead with the second wave from today. And we have an entire set of interesting new topics which we will be doing same as we did for wave 1. Wave 1 also and wave 2 both we will be doing these talks on every second and fourth Tuesday, only one theme at a time, and at 4 o'clock on every second and fourth Tuesday. So just to set a context about who we are, particularly for those of our attendees who are coming for this only one theme for the first time. Venture Center, we are a leading inventive enterprise incubator. We are already 16 years old and we are working with startups. We are registered as a Section 8 not-for-profit company, and way back in 2007, we have started our working. A lot of credentials to our credit, the most recent one being the best incubator for nurturing intellectual property. That was the award which we got recently. Our mission is broadly to nucleate and nurture technology and knowledge-based enterprises by leveraging the scientific and engineering competencies in the broader region. We focus on areas like healthcare, biotech, biomed, energy, environment, water, sanitation, hygiene, and a lot of engineering, electronics, and engineering services, as well as domains like agro, secondary agriculture, food, and nutrition. Broadly, this is the ecosystem that Venture Center offers to the startup community. This includes infra facilities, mentoring, funding, a lot of plug and play lab facilities, prototyping facilities, testing, analysis facilities, regulatory facilities, as well as technology transfer and intellectual property offerings. So the current only one theme series, which is a TechX offering, is going to be hosted by the TechX vertical at Venture Center. This is the incubator snapshot, and you can see we are supporting a lot of startups in the healthcare, clean energy, and agro and engineering domains. We have already our virtual presence in 22 states via our different mentoring programs and city camps. These are some of the facility images, and I will request you to visit Venture Center anytime you are in this part of the country. These are our social media handles, and please feel free to follow us on all our handles, as well as you know, this series is streamed live on YouTube. So please do follow our YouTube handles also. Talking a little bit about our TechX vertical, Venture Center is the technology transfer hub for this region of India, where we have our jurisdiction into the states of Maharashtra, Gujarat, Madhya Pradesh, and Goa. The focus of TechX is to facilitate win-win tech commercialization partnerships. And this we do via our various service offerings, which include tech commercialization, policies, IP protection, and decision support facilities. And we do a lot of industry academia partnerings through our various programs. For more details, please feel free to contact this email address as well as our mobile number, which is shown on the screen here. So with this brief introduction about Venture Center and TechX, let us now begin with today's session. Welcoming Mr. Ravi Bhola, who is the managing partner for K&S Partners. Today's topic, which Ravi is going to address, is Biodiversity Act and the 2023 amendments. Giving a brief intro about Ravi. Ravi has extensive experience in patent and design applications across diverse technology sectors, which include biotechnology, software, nanotechnology, and many more such domains. Ravi is a trusted advisor for patents designs, offering insights on licensing, oppositions, IP strategy, and enforcement. He collaborates with multinational corporations, startups, and industry bodies, which includes IPR Committee of FICCI and CII, as well as the National Committees on Biotechnology and Pharmaceuticals. Ravi's contributions extend to the Association of Biotechnology-led Enterprises and also to the Institute for Stem Cell Science and Regenerative Medicine via their various committees. So with this very brief introduction, Ravi, welcome to the series once again, and over to you.
Thank you so much, Mukta. Good afternoon to everyone. And I'm really delighted to be part of the second set of series that you're running, and delighted to do the inaugural piece. And thank you everyone for joining in the call today. Um, as Mugdha indicated, that I'll talk about the recent amendments which have been brought in the area of biodiversity. And I'll talk about some of the major changes that have come in and how it may have an impact for industry, for academia, for R&D and other organizations. See, when the biodiversity law, originally when the law came into existence about 20 years ago, the principal objectives around having biodiversity law was that the Indian biological resources, which means Indian plants, Indian animals, Indian microbes, all these Indian biological resources need to be conserved so that they don't face extinction. Wherever they are used, let's say for commercial purposes, they are used in a sustainable way. Okay, so we don't exhaust all of that. And third was, through any of those commercial activities which are undertaken in a sustainable manner, whatever profits, so to say, let's say industry makes, some sort of benefit sharing of those profits should be made with the communities that are responsible for conserving that Indian biological resource. So essentially, these are the three objectives with which biodiversity law came into existence. And somewhat similar laws in terms of similar objectives came about in several countries, especially the countries which are rich in biodiversity. So we had this law which came in 20 years ago, and it took 4 or 5 years for the entire framework to be operational, biodiversity law to start conducting hearings and get into benefit sharing arrangement with the industry and even other organizations that are using Indian biological resource. So while the intent of the law was, of course, very, very noble, overall, I think the way the law got implemented, also certain conditions were imposed, the way the organizations were categorized as Indian entities and foreign entities was also a challenge. And there were many other aspects which led actually R&D heavy organizations, the ones which are using Indian or were using Indian biological resources, to either slow down on their research or try to get biomaterial from outside India to avoid biodiversity law related challenges. Or in some cases, I know of some startups and young organizations even shifted base to outside India. So those were some difficult decisions were made because of the way the law was implemented.
Hello, Ravi. I think we are losing parts of your conversation.
By entire
Hello?
life science. Hello?
Yeah, I think we are losing parts of your conversation. Maybe you want to cut off your video?
Yeah, or maybe, I think it could be because of my current internet connection. What I'll try to do is shift to hotspot.
Yeah, maybe. Yeah.
Yeah. Is it better now, Mukta?
Yeah, I can hear you better.
Yeah, I've
Maybe
just
you're also
shifted to
sharing some slides. You have
I will.
access.
Excellent. Thank you so much. So yeah, so do let me in case you face some issue in future. Huh? All right. So with all that so there were challenges. And in last 7, 8, 10 years, particularly different industry bodies reached out to different government departments in machinery to push for reforms in the biodiversity law. And I'm really glad that after this years of efforts, I'm sure Venture Center also played its role in terms of reforms in the law, that we had a draft bill which was shared with the stakeholders in December of 2021. And just last month, we had a law which was passed by the parliament, which is somewhat very similar to the bill which was circulated in December of 2021. So I'll talk about some of the major changes that have happened. Also, there are few items which are still not clear, and we'll get those clarities as the corresponding rules get framed and also corresponding ABS guidelines may get framed. But whatever we have seen in terms of the act per se, the substantive part of law, most of the changes are positive and in interest of the at least the Indian industry for sure. I'll start sharing some slides to talk about some of the changes. Okay. I presume you all can see my
Yeah, we
screen
can see
now.
your slides. Yes.
Excellent, excellent. So, first thing is about removal of Section 58 from the original act. Section 58 has been removed. What was Section 58? It talked about, any contravention of biodiversity law could lead to imprisonment. It could lead to issuance of non-bailable warrant. And then we have had instances, for example, in state of Madhya Pradesh, where in some of the companies, the leadership team was imprisonment on the perception or the view that there is some contravention or some Indian biological material is being used without due process. I know even in state of Karnataka, we heard about in academia, we had cases where certain deans and senior people in the research facilities had to face some challenges. And this was one of the biggest pain point we had in the earlier version of biodiversity law, that a lot of time when the law is not clear and you undertake some research activity, it could be totally unintended, but may come across as contravention. And therefore, while you can have environment around penalty and fine if ultimately the contravention is established, but putting researchers and leadership team in the businesses behind bars is definitely not the desired outcome. And I'm glad to inform you that with the amendment in the law, the criminalization part of the remedy is being removed. So while there are still penalties, and I'll talk about some of the penalties, and in fact, in some instances, they have increased the penalty amount in case of contravention. But the big relief for the researcher community and for the industry is that the offenses have been decriminalized. So no criminal action will be initiated against the organizations if they are found to have in any manner contravened the biodiversity law. So that is one welcome change that we have seen. The other change that we have seen is that Section 3.2, which actually in a way help determine which organization will be considered as an Indian entity and which organization will be considered as a non-Indian entity. Now there's a more logical categorization of that. So in the previous law, the way the Section 3.2 was worded, any, let's say, company incorporated in India, okay, and if it has even one share which is owned by a foreign national or owned by even a NRI, non-resident Indian, or you have a situation where in an Indian company incorporated in India, if somewhere in the management there is a foreign national, even if that person is not a shareholder, but just is in a management role of some form, then in that case also that company which is incorporated in India would be treated as a foreign company or a non-Indian entity. So there were those kind of ways in which the companies were categorized as Indian and non-Indian. Now, as you can imagine, the law, biodiversity law for Indian biodiversity is generally more liberal to the Indians because the Indian biological resource, the law is more liberal to Indians, defined as Indian as per the law, biodiversity law, vis-a-vis the non-Indian entities. So it's more stringent for non-Indian entities. Okay. So, but the problem was the way the classification of companies took place. Um, just think of it. Your companies which are traditionally known and seen as Indian companies, your Tatas, your Reliance, your, any of these even companies set up in India 150, 200 years ago or whatever, they all were technically or legally considered as non-Indian entities because maybe they're listed companies. If some foreign national has bought even one share, suddenly the company becomes a non-Indian entity or non-Indian company per the biodiversity law. So that was a challenge we had under the previous law. And the moment you become a non-Indian entity per the law earlier on, you can't touch any Indian biological resources or any Indian
Ravi, we have lost you again. Hello.
without getting NOC from the Biodiversity Authority. So the law was so stringent in the way, especially it was categorized, and therefore, it was important for the definition of Indian and non-Indian to be rationalized. And the good thing is now with the amendment we have in place, there's a more rational or logical categorization of Indian entities and non-Indian entities. So with the new definition, what happens? If you're an India incorporated company, and if you have shareholding by a foreign national or a foreign company,
Ravi, we are again missing out parts of your conversation. Hello.
or if you can appoint.
Ravi,
Yeah,
again, I think your connection is.
I will stop my video. I'll stop my video. Yeah. I hope it's better now.
Yeah, it's better.
Sorry for that. So then with this, so only if you have a majority shareholding by a foreign national or a foreign company, or if you have majority control in terms of appointing number of directors on the board, or through a shareholding agreement, you have majority control, or you are in the management calling all the shots, that's when you will be called as a non-Indian entity. That's what the new law says. And this definition is in sync with the Companies Act. Okay, so that's second big reform that has happened through the amendment in the biodiversity law. So it's a more liberal and a more reasonable interpretation of which kind of companies will be constituted as Indian companies vis-a-vis those will be constituted as non-Indian entities. And therefore, many young companies, startups, you can imagine startups often get investment from US. And I myself represent many startups that shifted base to either Malaysia or Australia because of some of the reasons, because of the law that we had. But I see now everyone has found this amendment to be a welcome change. And I'm hoping that the companies can stay back in India and continue to contribute towards the growth of the country. So I think, so this is again a very positive change. And as I said, when this change is in sync with the Companies Act, it also brings in more consistency and predictability for the businesses. And all businesses want is consistency. That one law should be in sync with the other law. It becomes easier to function as a business. So this is the second big change that we have in the amendments. Um, Let me move to the next point, and this is about another change that has come in with the amendment of the law. Now, just to give you some background, Section 7 is directed towards Indian entities. Okay. Now you have to see it in light of the amendment as to what will constitute as Indian entities. Section 7 broadly says that if you are an Indian entity, you can use Indian biological resource for research, no problem. You don't have to take any permission before doing any research. But before you commercialize your, let's say, product or a technology using Indian biological resource, you have to intimate the state biodiversity board from wherever, let's say, you have obtained the biological resource or wherever you're doing your research. So that is broadly what Section 7 says and is directed towards Indian entities. Now, what amendment has done is there's so originally law said that for certain entities, even that intimation to biodiversity board is not required, right? So there were certain exceptions that in those cases, Indian entities don't even have to worry about intimation. They can not only do R&D, but also commercialize. Those exceptions were applicable to, you know, what you call the cultivators of the Indian biological resources, or people who were responsible for conservation of Indian biological resources. So they didn't have to worry about prior intimation, then farmers and all of that. Also, as per the earlier law, hakims or vaid वगैरह के लिए भी you were not required to take any give any prior intimation before commercialization, because hakims and vaids were practicing for their own livelihood and things like that. Now that was the earlier law. What the amendment has done has expanded the scope or the category of entities or organizations who are now falling, who are exempted under Section 7. That is, these additional entities don't have to intimate before commercialization. What are those activities or entities that have been provided under the expanded version of Section 7? This is codified traditional knowledge. So for example, I'm using Tulsi. It has certain known, properties. It's codified. I use Tulsi for whatever that purpose, which is under the codified traditional knowledge. I don't have to even intimate any state biodiversity board before I commercialize anything around Tulsi, as an example. And when they say codified traditional knowledge, the new law, has referred to the Drugs and Cosmetics Act, where certain kind of list of literature is mentioned as a codified traditional knowledge. So you can always refer to that list under the Drugs and Cosmetics Act. And if you're doing anything which falls under that traditional knowledge for any commercial activity, you don't have any obligation as an Indian entity for any intimation for any commercial activity that you undertake. So in other way, it's more exceptions are available. Law has become more liberal. Another category which is added in the list of exception categories is cultivated medicinal plants and its products. So if I cultivate, let's say, I cultivate, turmeric, aloe vera, and things like that. So it's cultivable. It has got medicinal property. I can have huge land parcel where I can cultivate medicinal plants, and I use them for commercial activities because they're cultivable. Therefore, there's no pressure on that medicinal plant in terms of extinction and things like that. So if I'm cultivating and then I'm doing commercial activities around that, I can enjoy the exemption under Section 7 as an Indian entity, or any product that I make. So let's say if I make serum out of, let's say, aloe vera or something like that, no problem. I enjoy the exemption. I don't need to intimate Biodiversity Authority or State Biodiversity Board, in this case, for prior intimation. Okay. Similarly, earlier the law was limiting to only VADs and Hakims. Now it's been expanded to the entire Ayush practitioner, those who are registered. So anyone who is practicing Ayurveda, yoga, naturopathy, in any way, or medication, Siddhi, homeopathy, things like that. If you're using Indian biological resources as a practitioner for your own livelihood, as a medical practitioner, you enjoy exemption for commercial activities you undertake as a practitioner. So that's again a welcome change in terms of expanded the list of indications and and biological resources, which Indian entities can commercialize and do things, and they don't need to have a prior intimation towards the authorities. So this is the third change that has come in now. Again, a welcome change in our view. Now, another interesting change, and here are some reservations about what the impact of this change could be. Now, Section 2 of the Biodiversity Act has been amended. Section 2, generally of all acts that you would see, will always talk about the definition. Okay, definition of different terminologies which require more clarity. So we have, of course, a definition for biological resource. Like at the beginning of the session, I said biological resources generally, your plants, animals, microbes, parts thereof, and that's broadly the definition in terms of biological resources. What this amendment that has been brought in has brought in a term of derivatives into the definition of biological resources. So earlier the term derivative was not there in the definition of biological resources. Okay, and the way derivative has been defined for the new law is that derivative means a naturally occurring biochemical compound or metabolism of biological resources, even if it does not contain functional units of heredity. Last part is important. Even if it does not contain functional units of heredity. Now, we all have been thinking about why this change has been brought in. And, we are looking at, one landmark case we had, what we call as a coal case in the biodiversity field. So what happened around 2016-17, the State Biodiversity Board of Madhya Pradesh, in its order, held that coal, if someone is using coal from underneath earth and is using it for commercial activities, coal, according to State Biodiversity Board order, is a biological resource. And therefore, there are obligations. That was the position State Biodiversity Board took in 2016-17 or before that coal is an Indian biological resource because it is formed from the fossils of all that biological resources, and hence it should there are commercial obligations on entities who use coal for whatever commercial activity. And the party which was impacted by the order of the SBB had filed an appeal with the NGT. Okay, now NGT as an appellate authority had passed an order, a landmark order, where they held that coal cannot be considered as a biological resource, because we generally, when we talk about biological resources, we're talking about a resource which can multiply, which can propagate, which needs to be conserved, and somebody's, let's say, cultivating it or things like that. Now, and biological resource was something
Hello, Ravi.
to multiply. Coal cannot multiply. It is fixed in terms of space and quantity, and therefore coal should not be. That was the order passed by the NGT. Now, one line of thinking is this definition of derivative has been brought in specifically to overcome that judgment, because here what the amended law says, biological resources include derivatives, and derivatives are defined as mentioned on the slide here as naturally occurring biochemical compound or metabolism of biological resources.
Ravi, we have again lost your voice. Hello, Ravi?
Yeah.
Yeah, sorry, we lost you for the last few seconds.
Okay, my apologies. I'll repeat. So therefore, in view of the amendment that has come in now, the scope or the definition of biological resources has been expanded per the new law. And this is something which I think many stakeholders are not very comfortable with. Of course, we'll continue to have dialogue with the government to see, how they look at it. We still have, draft rules and guidelines to come in. But since it's sitting in the substantive portion of law, we believe this can create a bit of a challenge. So, for example, tomorrow I use natural gas, I use, petroleum for some
Hello, Ravi,
others
again,
with
yeah, petroleum, you're giving examples, we lost you there.
Yeah, so I was just talking about, let me see if I can find a better way to just give me a second. My internet here looks to be okay. Okay, I'll try my luck one more time. Yeah, just give me a second. Yeah, so let's hope that it's better now. So as I was telling, that things like going by this new definition, I mean things like natural gas, petroleum, all of this.
No, we have again lost you. Hello?
Functional units of heredity, and then therefore all these things, all these kind of resources may now fall under the category of biological resources per the new definition. So we'll see how that evolves, but this change has not been generally well received in the community. So we'll see how that plays out. Then other things.
Ravi, you may have to check your connection. We are losing you again. Hello?
Hello?
Yeah, we again lost you for last few seconds.
Oh, I'm really sorry. I'm just wondering how to fix it. My apologies. Now, the other change that has come in, which again, in my view, is a positive change, is around the interplay of IP law or the patents in particular and the biodiversity law. So as per the earlier law, the requirement was that even when you file a patent and you have used Indian biological resource as a part of your either testing or for your product or your process or technology, you will, while you can
Hello, Ravi? Hello? Hello?
that was, yeah.
Yeah, again, the last few seconds.
Oh, I'm sorry. I'm just wondering, should I shift to another room?
We're losing parts of your conversation in between.
Oh, I'm so sorry. I moved from office Wi-Fi to hotspot, but it seems maybe in this area we have a challenge. Can you give me 1 second? Let's see if I can move to another room.
Sure.
Just give me 30 seconds.
Yeah. Meanwhile, if anyone has questions for whatever has been covered up till now, please feel free to use the chat box. Also, those who can see their names as Sharvari Naik, please rename yourself by right-clicking against your name and renaming with your own name. We are just waiting for Ravi to join back. He's trying to go for a new connection, internet connection. So please hold on.
Hello, Mukta.
Yeah, hi, we can hear you now.
Okay, I just hope and pray.
Yeah.
This is better.
So
Okay.
there are a few questions in the chat box. Do you want to take them now or?
Yeah, I think we can take them now.
Sure. So Dr. Premnath wants to know that can you again tell us how a foreign company is defined now with the amended law? Hello, can you hear me? Ravi, if you're speaking, we are not able to hear you.
Hello, Mukta.
Yeah, did you hear the question? Should I repeat?
I think I lost you, but I think the attendee wants to know how the company is categorized now differently
Yeah, the
from the way
foreign
it
company,
was.
how is it defined now?
Different. Yeah. So as I indicated earlier, the earlier definition. So maybe I'll just focus on how the companies are defined now, so that it probably will be better. So now, if you are a company, let's say incorporated in India, and if you have a shareholding of more than 50% by a foreign company or a foreign national or an NRI, then you are treated as a non-Indian entity, even though you are incorporated in India. Okay. Or through any shareholding agreement, you have the majority control over the company, or you have some authority through the agreements, which gives you an opportunity to appoint majority of directors on the board of that company. So these are some of the scenarios in which, though you are formed and incorporated in India, you will be seen as a foreign company. So overall, essentially, if you have a majority, simple majority, more than 50% in equity, or through control to appoint directors on the board, then you are considered as a non-Indian entity. And therefore, more stringent law is applicable to you. However, if you have shareholding less than 50%, then you will be treated as an Indian company. As per the Biodiversity law. And as I said, it is similar to the Companies Act in that sense. Yeah, Mukta.
Yeah, we can move on.
Yeah, okay. All right. So we were on the IP element here. So as I was telling that earlier, the law was that once you file a patent application, then before you are granted a patent, you have to have an NOC or a benefit sharing agreement with the Biodiversity Authority, and then only your patent will be granted by the patent office. That was the law. Now with the amendment, what happens is that if you're using Indian biological resource, then anytime during the pendency of your application with the patent office, you have to just register yourself with the Biodiversity Authority that I have this patent pending with the patent office. Just the intimation, that's it. Your patent application examination and grant will not stop because of any pendency or of negotiation or any benefit sharing agreement that you may have to enter with Biodiversity Authority. And the intent was there are about 1,000 plus applications for patents which are pending with the patent office under the old law. Because of the delay in implementation at the Biodiversity Authority or because of negotiations which can take time, all these applications were getting pending with the patent office. Now with the amendment in the law, patent office need not wait for any NOC or benefit sharing agreement that a patent applicant needs to have with the Biodiversity Authority. patent office can go ahead and grant the patent. The obligation under the new law is, before the commercialization of that patent, the patent applicant or patentee has to get the permission from the biodiversity authority. So I hope it is clear. Earlier, patent applications were struck up because of ongoing negotiations or conversations between the patent applicant and the biodiversity authority. Now, patent office need not wait for that negotiation to conclude. They will go ahead and grant the patent. The onus on the patent applicant is that when they file the patent application, and if they have used Indian biological resource, they just intimate biodiversity authority that I have filed a patent and have used Indian biological resource. It's only when they have to commercialize that patent is when they have to reach out to biodiversity authority. And then if the biodiversity authority believes benefit sharing agreement or NOC is required, then that activity can happen at that point in time. So that's again a positive change that has happened, so that the patent applications don't accumulate with the patent office, and they keep clearing it and get the patent granted. So that's again a welcome change that has come in through the amendment in the biodiversity law. I'll move further to the next amendment. And the next,
just one question in the
yes.
section.
Yes.
The derivative addition is draconian. So any changes in what is classified as a traded product in the schedule?
Yeah. So I think what would happen in my view, because it has gone through the approval from the parliament, I don't expect that this definition of derivative will get changed, because it has gone through the scrutiny. And I don't think it will come back to parliament again for another round of amendment anytime soon. The only thing we expect is that on-ground interpretation of the definition derivative. If the interpretation is more liberal, both by the biodiversity board or the biodiversity authority, and also ultimately by the court, then we can expect some relief. Otherwise, I think for time being, we have to be mentally prepared that the expression derivative is not going anywhere soon. It's just that we have to try for a more reasonable interpretation of the definition derivative. And that can happen, as I said, through the practice and the procedure that various states biodiversity boards will follow, and also what NBA will do in their negotiations and decisions. And of course, if any appeals are filed with the NGT or with the courts, then how courts will look at this issue. So that's how I think it will play out. Yeah, I see Dr. Premnath has some point to make. Yeah.
Sorry. Hi, Ravi. How are you?
Hi, very well. Good evening. How are you doing?
Good. I just wanted to ask you, suppose, somebody is taking a raw material A and, processing it through steps B, C, and in these processing steps, there are multiple players involved, right? For example, there's a player A, then player B, player C, and it's handing over from one to the other. How is the law applied, in the sense, who out of them is responsible? Are each of them responsible as far as NBA is concerned? I mean, even if patents are not filed, still some commercial obligations might be there, right? Correct. So how is this interpreted, please?
Yeah. So, great point, Dr. Premnath. So, typically what we see is that, if ultimately a lot of onus, unfortunately, I would say, falls into ultimately players who are downstream the process. Unfortunately, the way it plays out. Ideally, at every stage, let's say from the starting point, some biomaterial is used, and then in steps, whatever A, B, C, D, different entities A, B, C, D are involved in processing it or adding another new biological resource into that process or whatever. Ideally, at each stage, whosoever has first procured that Indian biological resource, onus should be on that entity, right? Because if I am at stage A and I have used some Indian biological resource, I have an obligation. I mean, whatever obligation per the new law. If I have not fulfilled my obligation and I have given it to party B and party B has used that plus added another element B, then that party ends up having obligation both for B, which they have added, also what they obtain downstream from A. So, so essentially at each stage, depending upon nature of biomaterial, obligation is to be determined. But as I said, on ground, what I end up seeing is that ultimately further downstream, the party D, which will actually may go for a significant commercial activity, they end up often, bearing the burden for all the steps A, B, and C. So this is generally how it works. But then also you have to be mindful of elements like now with a longer list of exemptions available, be it under Section 7 that I talked about, or some of the other amendments that I'll talk about in the subsequent slides. Uh, Everyone in the chain may not have the obligation, only some may have. So that's how it has to be determined at a micro level. Yeah.
Thank you.
Yeah. So now this amendment is around Section 59, and this is essentially to bring in more clarity. So earlier, the Section 59 talked about that, okay, while you have an Indian biological resource and that you have obligations under biodiversity law, and those obligations will stay even though you will have other IP also emerging through the usage of that Indian biological resource. So like for patents, we talked about the interplay of biodiversity law and patents. Here, the clarity, a good clarity has come in, which says that if you have developed, let's say, a new plant variety in India and you have sought registration under the Plant Variety Act, then you don't have any biodiversity law related obligation on that new plant variety that you have got approval from the under the biodiversity under the plant variety protection law. So here they have clarified in a way and made life simpler to the extent that for registered or approved plant varieties in India, Indian plant varieties, you don't have any obligation under the biodiversity law. So that's a good change that has come in. Otherwise, entities were a little confused in terms of, do I still have an obligation under biodiversity law and things like that. So this is a positive, clarificatory change. Now, I have two more slides to talk about two other kind of significant changes in the law. This again is in a way, a positive change. Section 40 of the law basically says that if you have if you're using an Indian biological resource or material, essentially for trading, that is, you buy it and then you sell it. Okay, if you're simply doing that as a trader, okay, as long as you're not doing any R&D on it and you're simply buying it and selling it, or let's say if you're a farmer, you're doing it, producing and selling it, then you are exempted from the biodiversity law completely. Okay, that is Section 40. That's how it was. Now, what they have done is they have amended Section 40 to expand the list of situations or biological resources where this exemption will be applicable. So which means it's a positive development. One change, for example, under the amendments is the expression items derived from normally traded commodities. So, for example, I grow or I buy tomato and I sell it. I was already exempted. Now, if I buy tomato and make a tomato puree out of it and I sell the tomato puree, I'm still now enjoying the exemption. Earlier, there was lack of clarity that if it's only for just buying and simply selling it, or if I can make some simple, you know, items out of that naturally traded commodities. Tomorrow I take mango and I make mango juice out of it, simple product. I sell mango juice instead of mango, which I had bought. Am I exempted or not? Now, with this amendment, those items are now also exempted under section 40. Another item which is now exempted is agricultural waste. So similarly, I have a agricultural thing happening and I, have ultimately end up having agricultural waste. Now, I may have processed the agricultural product and that's how the waste has come in. And I, sell the waste or whatever, I'm exempted for that kind of a commercial activity. Of course, some people are saying that, other kinds of biological waste should also be exempted. But of course, right now, the way the law is amended, it's limited to only agricultural waste. And then, of course, last bullet point here is a kind of an extension of what you already had seen in section 7, which is for Indian entities, that the cultivated medicinal plants and their products, again, are exempted, which you have already discussed, so I'll not get into it. But what is important to remember is that, as the last line here says, but the moment patent is
Hello, Ravi. Hello.
making a tomato puree or a mango juice out of it, but you do further R&D and you, let's say you innovate something, and then now you want to file a patent for it, then your obligations are triggered, right? So that's the important point, that if you are simply acting as a trader or you're simply making some simple downstream process or product out of that commodity, then you are fine. But the moment you get into R&D mode, the moment you do innovation, then you want to seek a patent, that's where the obligations are triggered. So just be mindful of this part as regards section 40 piece. Now, quickly, I'll move on to the last piece I have, which is about
Hello, Ravi. Hello.
about the amendment is.
So section 55, the starting part we've missed.
Yeah, no worries. I'll repeat. Yeah. So under section 55, the amendment has brought in an increase in the penalty amount for in case of any contravention of any provision of the biodiversity law. So if you recall, in the beginning of this session, I had indicated that one positive change of the amendment is that, the any contravention, there's no criminal action which can be initiated. That's a positive change. But the counterweight that government has provided here is that the fine amount or the penalty amount is being increased in case of a contravention. And there are three levels, at which the contravention penalty amounts are defined. First level is, it is a contravention. You can face the penalty amount which can range from 1 lakh to 50 lakhs. That's one level. If the damage caused by contravention, damage in terms of damage to the biological resources or whatever, if the damage is of significant level going beyond even measure of 50 lakhs or so, then based on the amount of damage caused, corresponding penalty can be imposed, which can be any amount. No cap identified there. The third level is that if you are a repeat offender and you continue to contravene even after all these adjudications or penalties being imposed in the past, then you can have an additional penalty of up to 1 crore. So the penalty amount have been increased significantly, and at multi level based on the situation. So that's, and if you see, we've seen the amendments in other kind of laws also that are happening. For example, amendments in IT law, amendment in other patent law aspects. The government's view under what they call as a Jan Vishwas Act is that cut across various laws, government is decriminalizing the offenses, which means imprisonment element is being diluted considerably in several laws in the country as we speak, at least 15, 20, 30 laws. They are decriminalizing the in case of contravention, but penalty amounts have been increased in all those laws where such changes have been brought in. So that's a theme that is emerging in terms of approach of the central government around these laws. Now, one more important element, and then I'll stop, is around appointment of adjudication officer. So earlier, the Biodiversity Authority used to, in some ways, if I can use the word arbitrarily, or SBB, used to quantify the damages and put some numbers as penalty. Now the new law actually provides a framework where central government will appoint adjudicating officers who could be at the undersecretary level in the central government or a secretary level or upwards in the state government, who can be appointed as adjudication officers. And they actually have been given some very significant powers to investigate any case of contravention, issue warrants, record witnesses, call witnesses, record evidence, and impose penalty. And there's a view that they've been given very sweeping powers, and can these powers be misused? So of course, we'll go as we go forward, we'll get to know. But earlier, at least, earlier we didn't really have any proper framework in terms of how these bodies will investigate and things like that. Now some framework is provided under the biodiversity law for investigations to determine whether there's any contravention or not. So I think as long as it is done in a reasonable, fair way, and it is not overindulgence, I think it's all right. But then in some quarters, there's a bit of a apprehension. Then can there be overindulgence in terms of investigations and some of the repercussions around that? So this is one change, one more change that has come in, and I'll stop sharing my screen, because this is what I had, and if there are any residual questions, I can take those questions. Yeah.
So thank you, Ravi. There are a few more questions in the chat box here. Dr. Ayushi from BCL, she wants to know, the patent office is asking the applicants to seek NBA permission. So what should a patent attorney do to save the best interest of the applicant?
So under the new law, of course, you have to now, since the new law is in place, we have to draw the attention of the, can you hear me? Sorry. Yeah. So under the new law, of course, you have to have conversation with the patent controller and sensitize the controller about the law, in view of which the grant of the patent should happen. The patent office and patent controller need not wait for the NOC from the Biodiversity Authority in view of the new law, and they should proceed towards the disposal of the application or grant of the patent. Now, also there could be a situation where under the previous law, certain applications were filed under Form 1 or Form 3 and those things. Now, with the amendment, if your category has changed and you fall under the different obligations under the biodiversity law, you have to, then, of course, you have to wait for the new rules that have to come in for the amendment that has happened in the substantive law. We will hopefully in next few months, hopefully if not in few weeks, you will see new rules being framed in sync with the law. So that will also provide us the basis to file suitable form And in the meantime, I would just urge you to engage with the authorities till the transition is complete. Yeah.
There's another question regarding exchange of microbial cultures between two countries for research purposes. Is there any amendment in the law in this regard?
No. So see, section 4 and section 5 in a way regulate the movement of biological resources and information or research data around biological resources. There is no shift in no amendment in the law around that. So that part stays the same. As I said, only thing is that if your category as an entity, Indian or foreign, has shifted in view of the amendment of section 3.2 that I talked about, that may have maybe to some extent any bearing. Otherwise, the amendments that have happened, all of these amendments, if you think of it, largely they are beneficial for Indian entities, if you think of it. For foreign entities or non-Indian entities, their obligations have not been reduced. Their obligations have stayed the same. Only thing is, with the amendment in the law, some of the entities which were considered foreign under the old law have suddenly now been considered as Indian entity, because we talked about, the majority shareholding and stuff like that. That is the shift you have to analyze. Otherwise, if it's a company sitting incorporated outside India, or any research institution sitting outside India, their obligation stays the same. So in that sense, there is no change.
Yeah, thanks, Ravi. This one more question. Do we need to take approval of NBA in Form 2 when the transfer of results is between Indian institute to Indian company without any foreign sharing?
Yeah, so if, of course, in terms of forms and all, you will see some changes as we go forward. The only thing is that you have to see so it's basically an act of commercialization, right? You're, as a research institution, you are giving it to a commercial entity. Now, under Section 7, as I said, your obligation is only for intimation under Section 7, if you are an Indian entity. And if you enjoy exemption, as I said, let's say for any codified traditional knowledge, or you're talking about biomaterial, which is a cultivated medicinal plant, then you don't even have to intimate the biodiversity, the authorities in any sense. So look at the nature of material, and accordingly, you can take a call which category you belong to and what kind of obligation that you may have. And as I said, that with the new rules that will come up, some of these forms and corresponding obligations will get further clarified. Yeah.
This question from Swati Shukla. The NBA provides a standard agreement. Are there any ways of negotiating the terms?
I would always encourage you as a lawyer to negotiate. And there are, of course, NBA can be pretty tough at times when you negotiate. But of course, there are certain things which will fall under the excess benefit sharing kind of guidelines, and they have some set standard numbers around it. But we have had good number of cases in last 8-10 years where we've been able to negotiate to significant extent on the draft which they share with us. And so I would encourage you, if there is any provision there which you believe is unfair or something that requires a change, I would say please push back on those things. They talk about deadlines and they put pressure in terms of timelines, which is fair from their end. But I would say buy more time and have those conversations to get a fair deal from them. Another thing, which I have noticed is that, and now with the reform we have seen in the law, law has become more, I would say, fair or reasonable, if I can use the word. And therefore, sometimes I feel that in some cases, we have to see it like tax we pay, or income tax or corporate tax we pay. So some of these things are part of that. So we might not be able to make our financial obligation to zero when we negotiate, but still, I think they also need to be fair when these negotiations happen. Yeah, and it can vary, from case to case, nature of material and things like that.
Thanks, Ravi. There's one just last question from Dr. Nidhi, but before that, let me remind everyone the feedback link is in the chat box. Please fill that up before you leave this session. Yes, over to you, Dr. Nidhi.
Thank you so much for providing me this chance. Ravi sir, it has been really a very enlightening session for us. I have a question regarding amendment in section 40. As you have said, but the moment patent is filed, obligations are triggered. So
Yeah,
I couldn't get this line. What do you
yeah,
mean by this line?
yeah. So Dr. Nidhi, what happens is that, let's say, if I give an example that I had given for tomato,
Yes.
if I use the tomato and do some R&D on that tomato, and let's say if I, you know, extract some, let's say, unique protein, or I create a formulation or a composition using extracts from tomato, mix it with in certain proportion with something else, and I get a very new, unique composition, and which has some benefit, medicinal or some other benefit, then I believe there's an innovation, there's an R&D happening, right? And then I may seek a patent for it. Now, it is no more an act which will be considered as a act of normal trade. Normal trade would have been, because section 40 talks about exemption in case you do a trade as a commodity. Bought tomato, sold tomato, or bought tomato, made a puree and sold puree. This is going beyond the intent of using a commodity. Now you're getting into innovation, you are seeking a patent, which means you used Indian biological resource, innovated, so your obligations are at a different level as compared to having simply used it for trade purposes. So that's where they're coming from. And that's, Dr. Nidhi, also the overall theme in the amended law. So what they're trying to see, if you look at the essence of what they're trying to do, they're saying, I don't want public generally who've been using Indian biological resources for day-to-day work for years and decades, farmers, communities. We don't want something which you can easily cultivate. There's no shortage, no? There's no issue of scarcity. So why to create a unnecessary hurdle for regular work in the society? But they're saying the moment you extract value out of Indian biological resource, that value is in terms of innovation, invention, which can lead to other commercial gains for you, other than the regular trading benefits, then you have commercial obligation, or you have a obligation towards the biodiversity authority.
So
That's the overall essence they have.
this means any research output, if that is being commercialized, then we have to follow the NBA guidelines and we have to
Yeah,
do all
you
this
have.
benefit sharing and all.
Correct. Of course, there are few exceptions again, as I said. But the overall theme is, yes, the moment you get into R&D mode, your obligations are triggered.
Because I faced the one of the situation like this where we have used rice straw, one of the inventor, and we was asking about this benefit sharing part. So we were just confused. Then why they have put this agriculture waste part under the exemption? So you cleared my doubt. Thank you so much.
Thank you so much, ma'am.
Thanks, Ravi. I know we are past 5 o'clock already, but do you have a few more minutes? There's one raised hand.
Sure.
If you are available. Yeah. So Vanita, over to you. We have unmuted you. Hello.
Hello, yeah. Thank you, Mugdha. Sir, I just wanted to understand, like when any company has done an NBA notification and everything before this amendment has come, they can modify something or not?
Modify in terms of application with the biodiversity authority?
Yeah.
Yeah.
So we
you
can tell
should.
them that now we are exempted.
Absolutely. So if you believe your interpretation is that under the new law you are exempted, you must do that. And while sometimes they may they may have a pushback or whatever, but don't get bogged down with that, because the law of the land today has to be implemented. The only thing that you, Dr. Vanita, you may have to consider is that under the new rules, they may say, okay, now apply under a different form or whatever, or make an application for transfer of that file under the new law with the new form. All that, of course, we have to do as required under the law. But now under the law, if you're exempted, you can then even send a simple letter to say, in view of the change in the law, I don't fall under any of your obligations. That's what my understanding is. And, as a lawyer, I would say, just a prima facie thing, that you can say, if you still have a contrarian view, please reach out to me next 15 days. Otherwise, I assume I don't have an obligation. Something on those lines you can do. But I would say wait for the rules to come in so that you can do it in a proper way with whatever form that they may have.
Okay.
Yeah.
Thank you.
Thank you so much.
Yeah. Thanks, Ravi.
Thank you.
There's one last final one from Dr. Premnath, but before I give it to him, let me remind everyone about the feedback link in the chat box, and also reminding all of you about the next upcoming session in this series, which will be on 26th of September, which is again a Tuesday at 4 o'clock. Thank you for joining us today, and over to you, Dr. Premnath.
Yeah, thank you. Ravi, I just wanted to ask you to comment on a specific sort of a case, just to understand what will happen in those circumstances, right? If you imagine, say, a medical product which, say, uses something like chitosan or collagen from natural sources, right? And let us say that they process it, and they do it as a trade secret, right? There is no patent to be filed. There's an end product at the end, which is value added from original raw material, but the patent office doesn't see it, right? So what are the obligations for such a company to the Biodiversity Act? I just thought I'll use cases because we get all these questions from startups or from companies. I have one last situation also. Okay.
So Dr. Premnath, in this case, there are two elements. One is your gatekeeper, as patent law has, as the biodiversity law has envisaged. One gatekeeper is your patent office, right? If you file a patent, you are then monitored, and then you have an obligation before you commercialize or whatever story. But then, as you rightly said, there could be instances where you're not seeking a patent. You want to keep it as a trade secret. Or in certain things, not every innovation may qualify to be a patent, right? It could be a value-added thing, but may not necessarily qualify to be a patentable subject matter. So in all these scenarios, again, we have to see what are the other possible scenarios. Now, for example, I presume here we're talking about an Indian entity, right? For the let's say amended law. Now, for them, the obligation is triggered under Section 7. Section 7, we talked about, okay, you have a obligation to intimate the State Biodiversity Board before you undertake commercial activity. That's what Section 7 says. It is independent of patent law. So even if you're not seeking a patent, but if you have used Indian biological resource, and if you're not enjoying any of the exemptions that we talked about in the presentation today, then you have an obligation to intimate the your corresponding State Biodiversity Board that you are about to commercialize. You use something which is the Indian biological resource. Now you've done your job of intimation. Now you can do your commercial stuff. State Biodiversity Board, at any point in time when they process that application, which can happen 6 months down the line, 2 years down the line, we don't know. They may come back and say, hey, first of all, they may not even come back at all. So you've done your job as an intimation, your job is done. But theoretically, they can come back to you 6 months, 2 months, 2 years down the line and say, hey, we have processed your application, you had intimated, our whatever committee has looked at that intimation. We believe the biological source you are using, let's say it's under stress, scarcity, da 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 da, and hence you have either some commercial obligation for usage of that, or we direct you to not to use that Indian biological resource. So they have that kind of an authority, because once you've intimated, your job of intimation is done. You can continue to do what you want to do after that as a trade secret, use it, commercialize it, but they will at some point in time look at it. Why are they intimated? So that they can choose, if any case require further review or regulation, then they can come back to you. So that's how it will work out, even when you're not going through the patent system. But if you're enjoying other exemptions that I talked about, that if you're using something which is a codified traditional knowledge, if you are using something which is what I talked about, what was that? Codified traditional knowledge or cultivated medicinal plants or their products. If you enjoy any of those exemptions, then you don't even need to worry about intimation to the State Biodiversity Board. So based on the nature of Indian biological resource, you have to take a call whether intimation is required or no. If intimation is not required, you're good. Nobody's tracking you. But if intimation is being made, then you have to be mentally prepared that theoretically they can come back to you if they believe that that biological resource which you're using has some challenge in terms of availability or abundance or scarcity or whatever. Yeah.
Okay. Another startup situation is where they say two companies, one is processing agro waste into some value-added products, and another company is providing a consortium of bacteria to process it, right? And it's a transfer of biological consortia, right? Now, there's no, I mean, there's going to be some kind of transfer document. What do you recommend they do, each of these parties?
Yeah. So I think if I understand it correctly, you have a consortium of microbes, and you're using it, let's say, for waste management, right?
Yeah.
Yeah, in a way. So now, so there are two. One is any potential obligation you have regarding the microbes. And for each of the microbe, we have to look at, again, if I presume all these microbes are taken from India.
Yeah.
And then you again have to see whether you enjoy any of those exemptions under Section 7 in any sense or not. That's one. Then same thing for, let's say, if it's the agricultural waste, then you have to see whether you are enjoying any exemption under Section 40 or not. And as I said, it's under Section 40. It was, as we mentioned, if you are doing R&D, which I presume is the case here, because you may have a unique consortium of microbes, and you're getting some interesting results in terms of waste management. If you're seeking a patent, then Section 40 piece, which I mentioned earlier, gets kicked in. So just be mindful of that if you're seeking a patent around it. If you're not, then for Section 7, you have to see whether you enjoy any of those exemptions, expanded exemptions. We talked about, codified traditional knowledge and all of that. If you enjoy exemption, you are good. If you don't enjoy exemption, either from patent channel for Section 40 or through regular intimation on commercialization, then you are good. Otherwise, you will have obligation for either of the two elements, either of the two set of biological resources. Yeah.
Okay.
It has to be very case specific, Dr. Premnath.
Yeah. No, great. Thank you for entertaining a few cases also. I can go on and on, but I know I've taken a lot of your time. So thank you so much. Really appreciate it, Ravi, taking time out. And of course, we look forward to hosting you again. Right?
Thank you.
Thanks a lot.
Thank you so much. And
yes,
really appreciate the opportunity, and my apologies for all the technical glitch that happened because of me. But thank you so much for the opportunity.
Thank you for your time.
Thank you.
And again, a reminder, feedback link in the chat box, upcoming session on 26th of September, which is again a Tuesday. So hope to see you, all of you, back again. Thank you, Ravi.
Thank you so much. Take care. Bye-bye.
Bye bye.